Welcome everyone to the Federal Bar Association Key Tam Sections, the Rounds FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy FCA cases. I'm Scott Oswald, chair of the Key Tam section with Tejinder Singh, who is a partner at Goldstein and Russell. Tejinder, hello.
Hey, Scott. Good to see you.
So for our November edition, we got some really interesting stuff here. The first is BidSolve versus CWS Marketing Group. It's out of the district court in D.C. And this is a case dealing with when statements are made under the tax code triggering the tax bar of the False Claims Act. Tell us, Tejinder, what is the False Claims Act's tax bar?
So those who have practiced in this area will know that you cannot bring a False Claims Act case based on violations of the Internal Revenue Code. Now, if you happen to know that your neighbor is cheating on his taxes, you can't bring an FCA case against him, even if his dog pooped on your lawn. You just have to find another way to resolve that difference. And so the tax bar is a provision that explicitly carves out causes of action under the Internal Revenue Code. What's interesting about this case is it's not under the Internal Revenue Code. It's actually about eligibility for small business contracting preferences. And so what happens in this case is that the plaintiff accuses the defendant of lying about its revenue. And to substantiate its revenue, the defendant says, well, here's our tax returns. And the plaintiff says, your tax returns are full of lies. And the defendant says, aha, tax bar. You can't say we've done anything with our taxes. And the DC District Court kind of rightly says, no, that's not what this is for. This is about actual violations of the tax law, not about small business eligibility, which you can bring an FCA case about. And that's kind of the first interesting thing about the case is that tax bar analyses just don't happen that often. And so it's interesting to see a court walk through what the tax bar is for, how it works, and how not everything that touches taxes automatically triggers it.
So this is kind of an interesting use of tax returns under the SBA regulations. The relators saying, hey, these tax returns are fraudulent, and the SBA relied upon them consistent with its own regulations here. Kind of interesting, huh?
Yeah, I think it's actually somewhat common for businesses trying to establish their smallness to give their tax returns to the SBA. What was different in this case is that the plaintiffs actually knew, based on contracts you've won, you've gotten more revenue than your tax returns say. And so they use that to kind of give the lie to those statements.
So Tejinder, let's turn to our second case. It's Odom versus Southeast Eye Specialists. It is a case out of the Middle District of Tennessee. And this guy's kind of an interesting procedural background. The court had denied the government's motion to intervene previously. What happened here?
That's correct. So previously, the government had done its investigation. And they said, okay, we're not going to intervene at this time. And then later on, they changed their mind. They decided they want to come in and intervene. And the court said, no, sorry, too late. You haven't established good cause for the delay. And so part of how the government and the relators tried to nevertheless help the case is that the government shared certain information that it had gained from civil investigative demands with the relator. And the relator used that information in an amended complaint, which in order to get over the pleading hurdles that apply to all False Claims Act cases, including Rule 9b. And so there's a discussion in the case about whether that's permissible.
And the defendant objected to that, right?
Yeah, that's right. So there have been some cases under Rule 9b that say you can't use discovery to clear the Rule 9b hurdle. And so the defendant said, this is the same thing. They're trying to use information they didn't have when they brought this lawsuit to get their claim past the pleading stage, and you're not supposed to do that. And the district court said, no, that's not right. This is a different circumstance. There is a part of the FCA statute that says that when the government gets information through civil investigative demands, it is allowed to share it with the relator if the Attorney General or his designee deem that necessary for a False Claims Act investigation. And what the district court says here is The Attorney General gets to decide if it's necessary. We're really not going to second guess it very much. And this part also counts as the False Claims Act investigation. So it's all okay, and it's not covered by those precedents about Rule 9b.
So there's a lesson, maybe in this case for Relators Counsel, when they are talking with the government or sharing information with the government that goes back to them as part of a sharing agreement, as an example. What's that lesson?
I think the big lesson is for a relator who is facing declination, it may still be quite valuable to go to the government and ask for any information they're willing to give you. A lot of times relators will have a situation where they know about a big important piece of a fraud, and maybe the government's not intervening for whatever reason, but it might be willing to fill out some of the gaps by giving information that was gained during its own investigation, or giving information drawn from claims data that only the government has access to. This can be a way to solve some of the pleading problems that relators often face. And I think the government will often hand it over. Sometimes, of course, it won't. There may be agency hurdles of reasons why it doesn't want to. But I would say that relators should think about going to both the federal government and to the states, to the extent states are implicated in their cases, to see if they can get information to file amended pleadings before they serve them and go forward in decline cases.
Now, the other issue that the court dealt with in the Odom case was this issue of whether alleging a scheme to defraud with particularities was enough to meet 9b. How did the court come out?
So the court here comes out in favor of the plaintiffs. And so this is a case based on violations of the anti-kickback statute. And so the question was really if you've pleaded the kickbacks part with particularity, but you don't have specific false claims to the government, what's going to happen? And the court says, we think you have to have a representative false claim, or you need to have some details. The complaint here identified apparently 20 claims that had been submitted to Medicare, which was not totally comprehensive, but was enough of an example, the court said, under Sixth Circuit precedent to get the case over the line.
So let's talk about Sixth Circuit precedent, because the Sixth Circuit just a few weeks before had issued a decision in Owsley versus Fazzi Associates, Inc. And here the Sixth Circuit dismissed the case on a motion to dismiss, holding that describing a private scheme, even in detail, is not enough to meet 9b unless the relator identifies specific false claims. What's interesting about this case, and how do we square it with the Odom case?
So the Sixth Circuit is one of a minority of circuits that adopts this position that you need to have one of two things to clear the 9b hurdle. You either need to have representative examples of false claims, which is the path through which the Odom case went, or you need to have firsthand knowledge of billing. And what's interesting about this case is that in Owsley, in a published opinion, the Sixth Circuit clarifies that what it means by that is it's not enough to have firsthand knowledge of just what the billing practices at the defendant are like, or the general procedures they follow. You actually have firsthand knowledge tied to particular individual claims if you want to go through that exception. And so it's really quite a narrow exception as articulated in the Owsley case. And it's kind of surprising, actually, that the panel clarified it that way.
So you listened to the oral argument in the case. Tell us about it.
So what was interesting about the oral argument is that Judge Kethledge, who winds up writing the opinion, if you listen to him at oral argument, you would not necessarily have thought that he was going to rule for the defendants. He asked very pointed questions of the defendants, including, so the underlying facts of this case are that the defendants are accused of falsifying what's called OASIS data. This is outcome assessment data that home health agencies have to gather, and it basically shows how sick their patients are. The more sick the patient, the greater the reimbursement the government gives to the home health agency for that patient's care. And so these home health agencies have an incentive to say their patients are as sick as they can possibly say. And sometimes they cross the line. They actually falsify diagnoses. And that's the accusation here. The plaintiff provided at least 7 particular examples where patient data had been falsified, but she didn't have the next step, which was the actual claims for payment to the government for those patients. And Judge Kethledge was kind of all over the defendant saying, look, what possible reason is there to falsify this data, if not to then overbill the government? Why shouldn't we just infer it? And the defendants did not have great answers to this. At one point, I think one of the defense counsel said, I can't think of a good reason, or I don't know what the reason would be, or something like that. And nevertheless, you get this opinion that comes out in the defendant's favor, but you see markers in the opinion that really reflect Judge Kethledge's concerns from oral argument. You know, he says point blank that she has alleged quite a few details about what's going on at the company, but she just doesn't have the one kind of detail that Sixth Circuit precedent requires.
So the final case we're going to talk about is Polansky versus Executive Health Resources out of the Third Circuit. And this case deals with what the government has to do before it can dismiss a case under the False Claims Act. And you and I have talked about this before. The courts are all over the map on this, Tejinder. Give us a little bit of history here that we've gone over previously, and where does the Third Circuit come out?
So the Polansky case is, in my opinion, perhaps the most interesting case about C2A dismissals, and that's because of the procedural posture of the case. In a lot of the dismissal cases, they're happening right off the bat. You know, the government does its investigation, decides there's nothing here and we don't want this case to go forward, they move to dismiss. Or sometimes the case is in the pleading stage. Polansky is very different. Polansky has gone many rounds of litigation. The plaintiff's lawyers contend they put in millions and millions of dollars of attorney's time. It's gone through all the discovery. And it's at the summary judgment stage. And so the question is, you know, is now okay for the government to jump in, having allowed this much rope to run, and say, okay, we're dismissing this now. And so as the case goes up to the Third Circuit, the district court had allowed the dismissal and an appeal was in front of the Court of Appeals. The appellate court says the standard is, first, the government has to intervene before moving to dismiss, but it doesn't matter that they didn't, because we're going to construe their motion to dismiss as a motion to intervene. Second, the standard for dismissal is the standard given by Federal Rule of Civil Procedure 41A, which governs voluntary dismissals by the plaintiff. And it has a different standard depending on the stage of the case, where if it's early in the case, you can always dismiss. Later in the case, you can only dismiss on terms that the court thinks appropriate. It's a pretty vague standard, but it's a standard. And then the court says it was fine for the government to dismiss this case. It goes through some of the government's reasons and says, yeah, no problem. And in the flavor of the opinion is that the government has very, very broad discretion to dismiss these cases. And the reason I think the case is interesting is because I thought Polansky was probably the relator's best chance to ever win one of these cases. I think that the trend in these cases has overwhelmingly been in the government's favor, but I thought the relator actually had some quite good arguments about why dismissal in this case could be unreasonable. And it appears that the Court of Appeals just kind of doesn't want to hear it and said, yeah, we're going to adopt a rule that might acknowledge in exceptional cases they can't dismiss, but this ain't one of them.
So for defense counsel, should defense counsel ever give up on trying to get the government to dismiss a case, even late in the game?
It's hard to say. You know, when we've talked to our colleagues on the government side, they always lament how many requests for C2A dismissals they're getting from defense counsel. They always say the defense is on us all the time about dismissing cases, and even in situations where we would never do it and it's hopeless. But if you think about it from the defense counsel perspective, there doesn't seem to be that much downside. You know, you try. If the government says no, you're no worse off than you were before you tried. And if the government says yes, then the case goes away. So I think that defense counsel has a lot of incentive to continue pushing these points. I guess the only thing they would have to weigh in the balance is whether they would somehow be squandering their own credibility with the government when they, by doing a sort of cry wolf thing where they do it in every case, they might undermine a case where at the margins they could get it, but because they've done it before, they don't have the credibility. But that's kind of a speculative concern. I think for the most part, you'll see defense counsel quite rationally pursuing these dismissals at every stage of the case, every time new facts emerge that they think help them out.
Tejinder, thank you. And thank you for joining us for the Federal Bar Association Key Tam Sections, the Rounds FCA News with Tejinder Singh. We'll see you next time.